This conference will now be recorded.
Welcome to Dr. TSPR show. This is Dr. Tangella Shiva Prasad Reddy alias Dr. TSPR. Namaste, Adab, hello. On the eve of 26th January, we are to celebrate Constitutional Day. India becomes a republic. Every Indian citizen, irrespective of caste, creed, or religion, enjoys right from these fundamental rights to the equality in welfare and developmental activities, because it is his tax paid money which runs the government, whether it is central or state governments, in the larger public interest, and they should run in a transparent and accountable way. And this Republic Day, there have been lots of theories doing around India and the Indian subcontinent. Majority versus minority. That has really baffled me. Why people forget that whether it is Pakistan, after Pakistan again Bangladesh, they have all been created out of our Indian subcontinent. ఇవన్నీ మన భారత భూభాగం నుంచే పాకిస్తాన్ కానీ తర్వాత పాకిస్తాన్ దానిలో బంగ్లాదేశ్ ఏర్పడడం, దాంట్లో మధ్యలో కాశ్మీర్. సో ప్రతి ఒక్క పౌరుడు చట్టపరంగా రాజ్యాంగబద్ధంగా అన్ని హక్కులు వారికి సమకూరుస్తూనే అటువంటి భారతదేశంలో అన్ని అనుభవించే విధంగా మన రాజ్యాంగం రూపొందించిన వేళ ఎందుకు ఇంకా మెజారిటీ మైనారిటీ అని ఈ వాదనలు వినపడతా ఉన్నాయి. తద్వారా ఒక అయోమయానికి గురి చేస్తా ఉన్నారు. నువ్వు ఈ కులంలో పుట్టినవు, నువ్వు ఈ కులంలో పుట్టినవు, నువ్వు ఈ మతంలో పుట్టినవు, నువ్వు ఈ మతంలో పుట్టినవు. ఇదే మెజారిటీ మైనారిటీ పాకిస్తాన్లో కానీ పాకిస్తాన్ నుంచి ఏర్పడిన బంగ్లాదేశ్ విషయంలో ఎందుకు మాట్లాడడం లేదు? ఇదే భారత భూభాగం నుంచే కదా ఇవన్నీ ఏర్పడ్డాయి. సో మరి అక్కడ మైనారిటీల పరిస్థితి ఏంది, మెజారిటీల పరిస్థితి ఏంది, మళ్ళీ ఇక్కడ మెజారిటీ మైనారిటీల పరిస్థితి ఏంది అనే ఒక వాదన వినిపించడం వల్లనే అందరికీ ఒకే విధమైనటువంటి ఆచరణ సాధ్యమైనటువంటి ఒక యూనిఫామ్ సివిల్ కోడ్, అంటే చట్టరీత్యా కానీ మిగతా హక్కుల రీత్యా కానీ, ఎట్లయితే రాజ్యాంగం హక్కుల విషయంలో కానీ సామాజికంగా సంక్షేమం అభివృద్ధి విషయంలో అందరికీ ఒకేలాగా ఉండేటువంటి మార్గదర్శకాలనండి లేక హక్కులనండి బాధ్యతలనండి ఏవైతే రూపొందించుకున్నామో అదేవిధంగా అందరికీ భారత భూభాగంలో అంటే భారతదేశంలో పుట్టిన ప్రతి ఒక్క పౌరురాలికి ఒకే విధమైనటువంటి చట్టం కానీ చట్ట పరిధిలో వచ్చే అంశాలను కానీ అందరికీ ఒకే విధంగా ఎందుకు ఉండడం లేదు అనే మీమాంస, దాని వల్లనే ఈరోజు మనము ఈ స్పెషల్ లైవ్ షో జనవరి 26 నాడు భారత రాజ్యాంగాన్ని అనుభవిస్తున్న వేళ ఈ యూనిఫామ్ సివిల్ కోడ్ ఎందుకు ప్రస్తావనకు రావడం లేదు, ఆచరణలకు ఎందుకు రావడం లేదనే దీని మీదనే మనము ఈరోజు ఈ లైవ్ షో ద్వారా మిస్టర్ G.B. రెడ్డి వారిని అతిథులుగా ఆహ్వానించడం జరిగింది. వారు తమకున్నటువంటి ఆ సమయంలో డాక్టర్ TSPR ఛానల్స్ ద్వారా యూనిఫామ్ సివిల్ కోడ్ పై మాట్లాడడానికి ముందుకు రావడం నిజంగా ప్రతి ఒక్క పౌరుడిని ఈరోజు చైతన్యవంతులు చేస్తుందనే నమ్మకంతోనే వారిని సాదరంగా ఆహ్వానిస్తున్నాం. వెల్కమ్ టు ది స్పెషల్ షో G.B. రెడ్డి గారు. వారి గురించి గతంలో కూడా 1956 వరకు రాజ్యాంగం ఏర్పడే వరకు ఏమి జరిగింది, రాజ్యాంగం ఎందుకు ఏర్పడాల్సి వచ్చిందని చాలా సున్నితంగా he has explained very crystal clearly the events leading to 1956 Constitutional Day so beautifully. While remembering all such events, today we are going to explore further from 1956 to till this day why we are not still unanimous in stating that we are all Indian citizens, why we are divided either by political class or by our own selfish deeds at the society level, in the caste, creed or religion way. This is not at all good for the country. So for that reason, We have invited Dr. G.B. Reddy Garu. Let me just put forward a small introduction in regards to G.B. Reddy Garu. Don't forget again, government has nominated him for law set or whatever it is to groom younger mindsets into legal officers. I congratulate him.
Thank you.
Professor Dr. G.B. Reddy, Professor of Law, Osmania University, Hyderabad, lawyer turned academician, studied BA, HPP, LLB and LLM Constitutional Law at Osmania University and PG Diploma in Human Rights from University of Hyderabad, obtained PhD in Law from Osmania University in 1999, started teaching law in 1991 and joined Osmania University in 1997 as permanent faculty. He possesses a brilliant academic record with 3 gold medals in LLB. No one can parallel this. And he's such a simpleton. That is why every student, every lawyer, and for that matter, those who are in constitutional positions, also they admire him. He is the first candidate to have qualified in UGC JRF in law from Osmania University in 1993 itself. He has successfully guided 13 PhD theses. This was 2 years back when this channel was launched. I think more would have added by this time. These 242 LLM dissertations and at present guiding 9 PhD scholars. He has a cumulative teaching experience of 3 decades at UG, PG and research level. He authored 20 well-received books on law, including Women and Law, Intellectual Property Rights and Law, Copyright Law in India, Practical Advocacy of Law, Right to Information, and Law and Judicial Activism in India. He also published 69 articles on law published in standard law journals and more than 30 newspaper articles. He offered 3 Swayam courses successfully in 2019 MOCOS and 2020 on human rights, IPRs, and environmental laws. He has been a visiting faculty at several reputed institutions, including the Judicial Academy, Excise Academy, CCRT, NARM, TS Police Academy, National Police Academy, Nalsar University of Law. He delivered more than 400 invited lectures on law and related topics. He has been the convener of the TS Law Set and TSBGC LSET for the years 2019 and 2020. He is also the International Student Advisor of OU, Director UFRO. He has special interest in judicial behavior, IPRs, AI, cyber laws, and gender justice. I am presenting Professor G.B. Reddy for you. Sir, I'll make you the presenter so that.
Yeah. Thank you.
So you are the presenter.
Okay. Thank you. Thank you so much, Dr. T.S.P. Reddy, sir. At the outset, I thank you and the TSPR channel for giving me one more opportunity to, in fact, present my views on yet another topic relating to the Indian Constitution. At the outset, I extend my warm greetings on the occasion of the Republic Day celebrated today, that is on 26th January 2022, and to commemorate the working of our Constitution for more than 70 years. And you know that 70 years term is too long a time in the life of a nation like the great India, that is the Republic of India, the Bharat. And this is the time to remember some of the constitutional goals as envisaged by the framers of the Constitution and the Constituent Assembly and what transpired in the Constituent Assembly debates. Probably many of the goals have been secured to a great extent, but one of the most, I won't say sensitive, but perceived to be sensitive, not actually sensitive, but perceived to be sensitive issue, namely the Uniform Civil Code, also called the Common Civil Code, And this particular code, which is supposed to be uniform for all the persons, irrespective of the, in fact, the religions, eludes us even today, even after 70 years of working of the constitution. This is one important aspect. There have been number of debates on uniform civil code or common civil code right from 1950s till now. The immediate cause that triggered the attention of the nation, attention of the intellectuals and intelligentsia on the uniform civil code has been, in fact, uh, a petition filed by one of the, in fact, uh, intellectuals of the country, the Chancellor of Maulana Azad National Urdu University, based at Hyderabad, Mr. Firoz Bakht Ahmed, who filed a public interest litigation before the Supreme Court just 2 days back. And here, Professor Bakht sought a direction to the government to constitute a judicial commission or a high level expert committee to prepare draft of the uniform civil code. This is one important issue. We can also, look at the background of the petitioner. He is not a pushover. He comes from the family of the first education minister of government of India, that is the great Maulana Abul Kalam Azad. He is the grand nephew, and he wants that the uniform civil code should be drawn in order to comply with our constitutional mandate and also the obligations under several international conventions. And to be very precise, he thinks that the uniform civil code is necessary for three important objectives. One is to secure gender justice, equality, and dignity of women. And on the same lines as the others have also pleaded all these years, he wants that the matters, you can call them the personal matters, such as the marriage, the divorce, the inheritance, guardianship, succession, adoption, so on and so forth, must be governed by the same law on all the citizens of India, irrespective of the religion. Needless to say that, in fact, Mr. Bakht wants the uniform civil code only for the purpose of justice. That is the precise reason why I said it is a constitutional imperative for securing justice, which includes gender justice, social, economic, and political justice as well. In fact, they implicitly include gender justice at all levels, equality at all levels, and the, in fact, the dignity of the women, more particularly the women belonging to all the religions, including the, the minority religions. This is one important facet. Well, I would like to call your attention to the constitutional mandate in the form of a directive principle of state policy, Article 44, which was Article 35 in the draft constitution, which was debated by the Constituent Assembly. So we can always go back to what happened as far as the discussion on Article 35 of the draft constitution is concerned. It says that the uniform civil code shall be introduced throughout the territory of India. And the ball was in the court, or ball is still in the court of the state. It is the duty of the state to introduce uniform civil code throughout the territory of India. What was the necessity of including this provision in the constitution? Please try to understand that any nation cannot tolerate or compromise with issues like national unity, integrity, sovereignty, security of the state, so on and so forth. But national integrity is one of the goals envisaged in the preamble to the Constitution also. And integrity is the result of people living together with a feeling of liberty, equality, and fraternity. I'm quoting the three slogans of French Revolution: liberty, equality, and fraternity. And in fact, Dr. Ambedkar also was very fond of using these three expressions. Right from the beginning till 25th November 1949, the great intellectual used these three expressions, and ultimately he advocated the principle that without liberty there can't be equality and fraternity, and without equality there can't be liberty and fraternity, and without fraternity the other two are not possible. So they are intertwined and interrelated, interdependent. What I am trying to bring to your kind notice is that when there is no fraternity, when there is no feeling of equality among the citizens, then ensuring integrity becomes a challenging task, and this is something which cannot be compromised by any nation and any citizens, responsible citizens. This is one important facet. Coming to uniform civil code, whatever may be the contribution of the Britishers to India, but when they left us to draft our own constitution, we came to have different sets of laws governing these personal matters, whether it is marriage, succession, divorce, guardianship, so on and so forth. For example, in the case of marriage, in 1950, when the constitution came into force, even today probably there is not much change except certain reforms in some of the personal laws. Hindu marriage is governed by the Hindu Marriage Act of 1955 because it was the result of codification of Hindu law. Then Muslims are governed by the Shariat and the principles which are recognized by Islamic law or Muslim law. Christians are governed by the Indian Succession, the Christian Marriage Act of 1872. Parsis are governed by the Parsi Marriage and Divorce Act of 1936. Point is very simple. Depending on the religion, we have different laws, and the rights of the people who are parties to the marriage are different depending on the different sets of laws. This is one important facet. So, one is governed by the Hindu Marriage Act. Of course, there are certain essential conditions. Then, Islamic law, no doubt, recognizes marriage not only as a contract but also as an ibadat. That's what they say. It's not only mamulat but also ibadat. In other words, it is a contract as well as a sacred thing. Christianity also recognizes the marriage as a sacrament. Parsis also recognize. In fact, they are very close. Today, there are a number of issues relating to the Parsi women marrying outside the community. They are almost excommunicated. Legal battles are waged in Calcutta High Court and elsewhere. This is, and look at the rights of the parties. The men probably, they are enjoying their status as husbands, but when it comes to the women, it is not uniform. The position is not secure, and there have been instances of discrimination against the women under the Hindu law, under the Muslim law, under the Christian law. And because, take for instance, many people think that this is a sensitive issue, this issue is raked up only to target the minorities, which is quite untrue. For example, take the case of Christian minorities. Till recently, till 10 years back, the grounds of divorce available to the man, the husband, were not equally available to the wife. And ultimately, after 2 or 3 high courts, including Bombay High Court, High Court at Hyderabad, and some other court, pointed out and struck down some provisions of the Indian Divorce Act, then only the amendment took place by the Parliament. Because if the husband was entitled to invoke only one ground for divorce against the wife, like adultery, etc., the wife was required to invoke two grounds: adultery coupled with desertion or cruelty, something like that. She was put to disadvantage. I'm not saying that the personal laws are meant only for dissolving the marriages. Just one instance. Take the case of divorce. The divorcees today, as far as the Hindus are concerned, one can get married anywhere, under the sea, or in the sky, or on the rocks, under the tree, whatever. But when it comes to divorce, it is only through the court. Dissolution is only through the court. And some states have made the registration of marriages compulsory, including the erstwhile Andhra Pradesh and Telangana. This is one important issue. But what about the position in other communities? Recently, we have seen the case of Shaira Banu versus Union of India, decided about 3 years back by the Supreme Court, where the instant talaq or triple talaq at a go was declared as unconstitutional by the Supreme Court on the ground that it violates right to equality of the women, the Muslim wives. And the government went one step forward, ultimately to say that, in fact, any person who pronounces such triple talaq instantaneously will be guilty of an offense, and he will be liable for certain punishment with 3 years imprisonment. Immediately the criticism came up, even from certain intellectual quarters among the Muslims, on the ground that if in the Indian Penal Code we have 511 sections or so, hundreds of offences which are created, and if 3 years is not the minimum sentence, how can you impose such a sentence on the husband pronouncing triple talaq at a go? Is it not discriminatory? Anyway, the matter is pending before the court, Supreme Court today. What I am trying to tell you is that if there was a uniform civil code, common civil code, same law being made applicable to all the religions, the necessity of, in fact, enacting such laws like the Muslim Women Protection of Rights on Divorce Act after Shabanu judgment in 1985, and Muslim Women Protection of Rights on Marriage Act enacted after the Shaira Banu versus Union of India judgment about 3 years back, they wouldn't have been necessary. This is the point. Then the real problem is this: there has been a seesaw battle between the political stakeholders on one hand, the legislatures on the other hand, and the judiciary on the other hand. This is the problem. And at the best, I can describe this as one step forward and two steps backward in the direction of uniform civil code. How, I will tell you. Because when this uniform civil code was introduced as Article 35 in the Constituent Assembly, initially it was in fact postponed to the later day. Later on the discussion took place, and I will share with you a few in fact snippets on the discussions that took place. Majority of the minority community members who participated in the discussion on uniform civil code vehemently opposed the same, and initially they came out with an amendment to Article 35, that is the present Article 44, saying that except in the case of the personal matters of minorities, they say state shall introduce uniform civil code throughout the territory of India. That was the original text. But what the other minority members, in fact the vice chairman who was in the chair, said that let the minority members be given more time to debate on this particular issue. So some of the members were very vocal, saying that personal matters and the religion are tied up with each other so strongly in certain cases, including Islam, that any imposition or introduction of uniform civil code would be counterproductive, would be violative of their freedom of religion. This was their argument. And you must also in fact analyze the response of the chairman of the drafting committee, Dr. B.R. Ambedkar. Dr. Ambedkar said that there are certain Muslim countries also in the world which have uniform civil code. He referred to Turkey as an example. He also mentioned that actually there is a uniform civil code in India in a certain part of the country. He referred to Goa. Even now people say the Portuguese code, which is still applicable, provides for same law being applied on the followers of all the religions in personal matters. But the opposition was so much that ultimately the Constituent Assembly decided to keep it as a directive principle of state policy in order to pave way for some kind of consensus among all the stakeholders. And recently, before the Supreme Court, before the Delhi High Court also, let me tell you, sir, 5 writ petitions were filed before the Delhi High Court. And one of the petitioners was the same Professor, Firoz Ahmad Bakht, and his petition was third or so. He argued the same, but in fact, the first week of this month, 2021, before the Delhi High Court, the government of India, in fact, replied to the petitioners before the Delhi High Court that enactment of uniform civil code is not for the courts, but it is for the legislatures. So then this is one thing. In other words, what I'm trying to say is that the government also is, in fact, uh, expecting some kind of consensus to be reached after deep thinking, thorough study, deep study, in order to, in fact, take steps to introduce uniform civil code. And we may go back to number of other, leading judgments. Most of you are familiar with those judgments. When this iddat period expired after the pronouncement of triple talaq by the husband, there was no maintenance for the divorced Muslim women. Supreme Court said it is not correct. She is still entitled in Shabanu versus Muhammad Ahmad Khan versus Shabanu Begum, 1985 Supreme Court. Chinnappa Reddy, Justice O. Chinnappa Reddy, who is supposed to be a great intellectual but with leanings on the left side, and he also said in the same year 1985 in another case called Jordan Daying Day, a case pertaining to in fact a matter from northeast India, that uniform civil code is desirable. If more than 80% of the people are governed by one set of laws, probably there is a need to in fact have a uniform law for all. But it was nobody's case that the law which is applicable to majority people must be imposed on minority community. Probably this is something, this wrong conception, which has been causing lot of apprehensions in the mind of those persons who are opposing uniform civil code. Uniform civil code doesn't mean that majority law should be imposed on minority communities. Absolutely wrong. And again, if anyone really analyzed this issue, they would find that Hindu law also is not free from flaws. There are number of flaws. Just one example I'll give you in the matter of succession, especially succession to the co-parcenary property. Hindu co-parcenary means one common ancestor plus 3 generations of males. For a very very long time, this was the definition. Male descendants. Later on, Mr. N.T. Ramarao wanted to change the entire scenario in Andhra Pradesh when he was the chief minister. He said not only the males, not only the sons, daughters also would be co-partners with certain riders. Then throughout the territory of India, in fact, an amendment was made to Hindu Succession Act in 2005 during the Congress regime, if I am not mistaken. Then, in fact, that particular amendment says that all the daughters will be co-parceners. They will have equal right in the co-parcenary property as the sons. Common ancestor plus 3 generations of descendants. That is one. Section 6 was amended. Today you will find that, in fact, every 2 years there is some new interpretation. There was one interpretation about 2 years back, Vinita Sharma's case, where the court held that whether father is alive or not, the daughter would be entitled to co-parcenary property, provided there is no registered partition before. Recently, we have seen that the Supreme Court extended the right of the daughters to the ancestral property much before coming into force of the Hindu Succession Act 1956. That means what? Before 1956 there was any property, then to that property also the daughters are entitled to get an equal share. This was a flaw, not the interpretation, but denial was a flaw which is sought to be rectified by the courts by liberal interpretation. What I am trying to say is that Hindu personal laws also, honestly speaking, have not rendered justice to the women to a great extent. That is the reason why, even after enactment of the four pieces of legislation on Hindu laws, there was Marriage Law Amendments Act in 1970s, and today, in fact, I'll give you one example, because when we are talking about Uniform Civil Code, there is some ground called Kyar ul Buluk among the in the Muslim law, option of puberty. It is a ground for divorce made available to the Muslim wives under a law made in 1939. Suppose a Muslim, women got married when she was a minor. After attaining the majority, she could repudiate the marriage by exercising her option. That was made part of a ground for divorce under the Hindu Marriage Amendment Act in 1970s. So here one of the best provisions has been borrowed from a minority religion's practice into, in fact, the majority community law. What I am trying to say is that there are best practices which are available in all the religions laws, all the personal matters which are governed by those religious laws. Uniform Civil Code should not be and is not expected to be an imposition of the majority law on minority community. I'll give you, some other insight about bigamy. In fact, bigamy is one contentious issue, and many people with lesser learning say that why they are marrying four times, why we should not marry, more than once, because Christianity discourages bigamy, polygamy. Then Parsiism discourages the same. Then Hinduism discourages, and they say that Muslims are marrying four times. I am not here to tell you that all the Muslims are not marrying four times. That polygamy limited to four wives has historical roots, and in fact goes back to the sayings of Muhammad the Prophet, the followers of the Prophet. Ultimately, during the Battle of Uhud, when many in fact males died in the Great War, many destitutes in fact were living in the society. In order to provide shelter to them, it was said that you can marry one, two, three, four, provided you can share your love and affection equally among them. And somewhere else it is also mentioned that it is not possible to share love and affection equally among more than one wife. And this is only a permission under certain circumstances. All the Muslim scholars know about this. There is no need to remind them, and only thing is those who are not aware must know this. And there are any number of Muslims in India who marry only once. It's not our case, but those who are marrying, certainly they have to remember these things. Anyway, this is one, and even though Indian Penal Code criminalizes the act of bigamy, there are two offences under the Indian Penal Code. Section 494 punishes a person for marrying more than once during the subsistence of first marriage. Then under section 495, the punishment is even higher. It is aggravated form of bigamy, especially when there is a concealment of first marriage. So that is applicable to all the religions. As far as the Islam is concerned, there is an exception made out in the personal law, which is followed by the followers of Islam, but only in exceptional cases. This is one. But one argument is this: suppose if there are four people, four wives, then there will be children. It might lead to population explosion and all. Then I don't know, because even among the Hindus also, there was no restriction on the number of wives a male could take up to 1955. It was imposed, monogamy was imposed only in the year 1955 under the Hindu Marriage Act of 1955. Anyway, this is one issue. So we have divorce also. Divorce without approaching the court, and unilateral divorce given by the Muslim husband, but there is a particular procedure for it laid down in the Muslim law itself. Like, there is an approved form of divorce where the divorce is pronounced at regular intervals when the wife is not menstruating, and there is enough time to in fact to go back on the pronouncement of the earlier first or second talak. There is possibility of reconciliation, but at the same time such a in fact a privilege is not available to others. Divorce is not the end of the marriage or not the end of the life, because just I am trying to point out an anomaly somewhere. Same is the case, for example, Justice Obul Reddy of Andhra Pradesh High Court, my great teacher Professor Nageshwar Rao, used to say that a person converted himself into Islam only to divorce his first wife, Hindu wife, because she was not giving him divorce. He became a Muslim. He said talak, talak, talak. When the matter came up before the AP High Court, Justice Opul Reddy said the lock of a Hindu key cannot be opened by a Muslim. The lock of a Hindu marriage can't be opened by a Muslim key. Similar things took place in Sarla Mudgal's case in 1995. The facts were very simple. A person wanted to divorce his first wife so that he could marry his girlfriend. He was a Hindu, his wife was a Hindu. When the wife refused, he became a Muslim. His fiancé, his lover became a Muslim. They got married. Thereafter, in fact, they started living like husband and wife, and by retaining their Hindu names only. When the child was born, Hindu name was given. When passport was taken, Hindu name was given. Right? Then two other similar incidents were brought to the notice of Supreme Court in Sarla Mudgal. Kalyani and NGO was in the forefront, and the Supreme Court was asked to decide whether such second marriage after conversion into Islam is valid. And Supreme Court categorically said second marriage is not valid. It is no marriage at all. When the first marriage is still subsisting, then even after conversion, one cannot contract second marriage. And there, Justice Kuldeep Singh, who was one of the judges in this case, he directed the government to explain the response of the government of India as to Uniform Civil Code. What steps have been taken? You file an affidavit within 6 months before the Supreme Court as to the steps taken by the government. Deve Gowda was the Prime Minister, and his government filed an affidavit before the Supreme Court saying that we don't have an intention to introduce Uniform Civil Code because it is likely to hurt the religious sentiments of the minorities. That was on record. Anybody can trace that. Same thing has been said, of course, in a different tone by the Supreme Court before the Delhi High Court this first week of January 2022, saying that it is for the legislatures. They never said that legislature will not enact, but for the legislatures, courts don't have any power. It is correct interpretation. I am not disputing, because the courts have their own limitations with regard to directive principles of state policy. The courts, for example, cannot direct the enactment of Uniform Civil Code under any guise, under any form, because they are not judicially enforceable in a court of law. But the point is, when the government says that a deep study is required, my only doubt is whether 7 decades of time is not sufficient to make a deep study of the issue of Uniform Civil Code. 7 decades. This is the point. So for during the last 7 decades, what the government has been doing? Why the efforts were not made to take everyone on board? All India Muslim Personal Law Board, or maybe some organizations relating to other minorities, then organizations relating to the majority community. Why in fact the best Uniform Civil Code could not be introduced? This is one question. Why it cannot be introduced now? Another question. Of course, if there is no Uniform Civil Code, the people are not going to die. But look at the impact of not having Uniform Civil Code, right? impact especially on the women. Women are the victims. Under every personal law, women are the victims. This is the problem. And because of the, in fact, interdependence of the religion and the, in fact, the laws, personal laws, it so happens that if one is touched, the people think that the other is touched. This is the real problem. What's the meaning of secularism here then? Here I would like to draw your attention to the opinion of the Law Commission of India. The Law Commission of India issued a consultation paper running into 185 pages on Uniform Civil Code in recent times, 2018. And time was given, consultation process was abruptly stopped. 185 pages, it is available everywhere. I think Justice B.H. Chauhan, the present Law Commission chairman himself was the chairman at that time. And ultimately what they say is Uniform Civil Code is not desirable at this juncture. And the learned judge goes on to say that Uniform Civil Code, probably, the objective of Uniform Civil Code can be, ensured by making reforms within the religions, within the communities. And of course, to support this point, we have number of examples. Take for instance, as far as Hindus are concerned, they agreed for codification of their laws, and today we have 4 sets of laws. You know that. Then number of amendments made in the matter of marriage, divorce, so on and so forth. Muslims, in fact, they have been, in fact, progressive in certain cases. Absolutely, we must compliment them. For instance, when Rajiv Gandhi government brought the Muslim Women Protection of Rights on Divorce Act after Shabanu judgment in 1985, where he said that, in fact, personal law will be applicable in the matter of maintenance to be given to the divorced wife by a Muslim husband. Then one provision of this particular act said that provision shall be made, for the purpose of, in fact, introducing or making provision for maintenance. Within that period, provision should be made for maintenance of the divorced wife. This was interpreted in 2000 in another case called Daniel Latifi versus Union of India, where the Supreme Court said that means it doesn't mean that Muslim husband has no, the right not to maintain the divorced Muslim wife beyond the iddat period. The rigor of the law is that he should make provision for maintenance even beyond the iddat period. This is the interpretation given in Daniel Latifi's case. The community has accepted. That means even the community is progressively thinking. Many intellectuals say that it's a good thing to do so. Same is the case with regard to the amendment of the Indian Divorce Act with regard to the divorce among the the Christian couples. And there are issues which need to be discussed. People say that co-partnership property must be abolished. Let there be no difference between self-acquired property and co-partnership property, because even Islam also doesn't recognize co-partnership property. All the properties are same, nothing like joint family and all. Property is property, right? There is no adoption recognized among the Muslims, whereas it is recognized among the Hindus under the Hindu Adoptions and Maintenance Act. About the guardianship, who should be the natural guardian? It is certainly arbitrary, because Hindu Minority and Guardianship Act 1956, the Guardians and Wards Act 1890, and other laws say that father will be the natural guardian of minor children. So after the father, it is the mother. Common understanding is that after the death of the father, mother will be the natural guardian. But Supreme Court in Geeta Hariharan versus Reserve Bank of India ultimately declared that after means not after the death, but during the non-availability of. How long the people of India should refer to judgments of the Supreme Court and High Courts on these matters? This problem can be avoided if we have a uniform set of rules regarding all the aspects, whether it is marriage, divorce, succession, guardianship, whatever. And as I already said, no sincere attempt has been made by any community so far to sit together and to deliberate on the desirability of uniform civil code after 7 decades of working of the Constitution of India. The deep analysis, deep thinking, or the deep study which is required should have been made by now. And if there is some kind of piecemeal reform which is coming up in all the religions, that is not sufficient. So we are only few steps away from, in fact, thinking that uniform civil code would certainly ensure gender justice. This is one important point. I hope that the communities will take cognizance of this important factor. And I can also imagine what's going to happen to the public interest litigation which is filed before the Honorable Supreme Court. The 5 writ petitions which are pending before the Delhi High Court are sought to be transferred to the Supreme Court. Then there will be a wonderful set of arguments on behalf of both the parties, and ultimately the Honorable Supreme Court might say the same thing as it said way back in 1995 or 96 after Sarla Mudgal's case, when there was a lot of criticism against the directions given by the Supreme Court seeking the response of the government of India. Then in Ahmedabad, the Working Women's Forum case, the Supreme Court said whatever we said is only casual observations made during the course of the judgment. Obiter dicta, ఉట్టుట్టినే ఏదో కావాలని జస్ట్ క్యాజువల్ ఆబ్జర్వేషన్ చేశాము, మా ఇంటెన్షన్ మీకు పర్ఫెక్ట్ డైరెక్షన్ ఇవ్వాలని కాదు అన్నారు. Today also the court might plead helplessness, and even if the court pleads, we should not blame the court for the simple reason that the court is helpless in this matter. What is required is consensus, understanding, and the preparedness on the part of all the religions, the political, because it may be a burning issue for many. To one may not really support it vociferously, openly nowadays, given the political stakes which are in fact going to be tested very soon. Therefore no political party would say that no, we want uniform civil code. That is another thing, but the reform must come from within the community. That is very, very important. So let us hope that uniform civil code would be brought in, and again by taking the best provisions from all the religions. That is very, very important. And India has to show the government, the public at large, the governments of the globe, the international community, that we are all united together, and absolutely there is nothing wrong. Otherwise, what is the reason for making a law for protection of rights on divorce, protection of rights on marriage, decriminalization of a certain kind of divorce, right? Again, some interpretation as to the guardianship of the father, some interpretation as to the maintenance, right? And not having certain grounds like incompatibility or irreconcilable differences for certain matrimonial reliefs. So the issue is endless. But I think Dr. Ambedkar would have been happy to have a uniform civil code in India, and any constitutional in fact scholar or any even ordinary citizen also would be very happy to have clarity, certainty, and equity also. This is equally important. Equity is required, and there need not be any parochial thinking, a narrow thinking on the issue of uniform civil code, because not having uniform civil code will certainly have some impact on the society. Someone might say, see, I am marrying somebody, in what way the government is concerned, or I am divorcing somebody, or I am not giving maintenance or giving maintenance, in what way the government is concerned. Point is very simple. We are following the rule of law. We can't approbate and reprobate. We can't accept and reject at the same time. Today, every human being is the beneficiary of the government schemes, the government's benefits, and these benefits must be equitably distributed among all. This is one important issue. So if any women belonging to any particular religion is suffering because of not having uniform civil code, honestly speaking, take the case of even certain other related aspects like Shabarimala judgment. that has created a lot of controversy. We have seen ultimately a review petition was filed. Now how many women are really worshipping in Shabarimala Ayyappa temple between 10 and 50 years of age? What happened? It has been something like, in fact, a great controversy which hit the peaks and came down naturally. What's happening now? Same is the case with worshipping by women in certain religious places. That is also another important issue. So certainly a progressive society always welcomes reforms. And on the eve of the Republic Day, I sincerely feel that the time is ripe. The public interest litigation filed by the Chancellor of Manu is only a triggering point, but a healthy debate must be followed, and definitely the viewpoints, not progressive viewpoints, not the closed mind, but the progressive viewpoints from all the stakeholders must be welcomed, so that certainly the national integrity can be ensured, dignity of women can be protected, then equality can be ensured, and the very objective of the constitution, that is to secure justice, social, economic and political, is achieved. So these are few stray thoughts. I have not referred to the consultation paper, 185 pages. One can always see consultation paper on Uniform Civil Code by Law Commission of India. One can refer to Shabanu judgment, available now freely everywhere, indianqanun.org. Even in Google you will find it. Shaira Banu judgment, then Shafiq Jaha judgment, right to marry a person of one's own choice, right? Then there are so many others. But ultimately, if this small presentation invokes or causes some meaningful dialogue and some kind of introspection or retrospection in the minds of at least a few intellectuals, I think the purpose of this lecture can be deemed to have been served. I thank Dr. T.S.P. Reddy Garu for giving me this opportunity. I only hope that I kept myself to my mandate, because this is a self-imposed mandate. Only the academic exercise. I have not crossed beyond, I mean, the Lakshman Rekha as far as the politics and other things are concerned. Thank you very much. Thank you.
Wonderful, wonderful, sir. This is one of the best lectures or discourses I think I would have heard from Professor Dr. G.B. Reddy Garu. Simple, straight, neat. You are trying to sensitize every community's intelligentsia. Here it is not majority or minority. Why I was trying to make people to understand majority, minority exists everywhere. So politicians for the sake of votes, or media for the sake of stoking the political bosses, if they are trying to inherit this culture of divide and rule, the British legacy which has left us, that is why I am trying to be very straightforward. When you talk about minorities and majorities, how long, even 70 years of after our constitution coming into force, how long we should keep on talking this, harping on this. That is why I compared this Indian subcontinent. Even Pakistan existed. What happened there to minorities? In Bangladesh, what happened to, because Bangladesh carved out of Pakistan. Both have been carved out of the great India, Indian subcontinent. So you have to understand. For that reason, specifically, as a nation, first India should come out with a proper understanding of each and every citizen belonging to every religion, caste, creed, whatever it is, or region, so that uniformity exists in the living, the lifestyles, which dictate our lifestyles and which dictate equity amongst all the welfare schemes or the development oriented aspects, or for that matter, any issue pertaining to the evolution of a human being or a family or a society or a country. For that, uniformity. If you, that is why we say India having such rich culture, so many castes, creed, and religions, we say we have unity in diversity. The same exists in our soil also. The richness of the soil, unity in diversity. From Kashmir apple to Kanyakumari coconut. Why not we try to get something at our personal levels? What is happening to this uniform civil code? Why we could not unite ourselves as human beings? Definitely religious heads, community heads all those intelligentsia should come forward. It is better late than never to project ourselves, if not for the world, so that we are united. Even when you have diversified religions, speaking or preaching, but when we come to human beings at the society level, at the country level, we should always feel whatever good is there in each and every religion, as been ably illustrated by our great Professor G.B. Reddy Garu, should be taken into consideration. We should not feel it is a majoritarian or minoritarian. No, it should be Indian. We should have an Indian approach. Indianism should be there. Only that will help us to come together, because we are not imposing one's will over the other. All those who are born in this great land are all Indian citizens. That should be borne in mind. Though we stand divided by the political or vote bank attitudes, we should not sway around. That has to be borne in mind. That is why we are trying to present this wonderful show with so many things to ponder over on this 26th January 2022, so that the intelligentsia of all religions, among all the communities, including Sikh, who have led the majority of our farmer struggle, they all pool in their energies to say we are all united. Come, enough of this nonsense, wherein we should not be disrespecting our own women folk, for that matter, our own selves. Why not we come together, irrespective of caste, creed, or religions? Because it is here religion which is really matters when it comes to uniform civil code. When such is the case, let us all unite, whether it is Christian, Hindu, Muslim, Sikh, Parsi, or any other religion. We should come together and very as quietly related, very neatly related, very constitutionally obligated. What is the constitutional obligation in this present conjuncture? Also, very clearly explained by Professor G.B. Reddy Garu. So let us all unite, speak in one tone. Let us take all good things from all religions, personal laws, so that we unite to get into uniform civil code. And in this matter, I really expect every political party and every government, whether it is union or state government, should come out not on party lines, not on divisive electoral beneficial lines. No, to keep India intact, so that this uniform civil code emerges, which we have found that uniformity of thinking of all the political parties, administrators, union and state governments when it has come to the great corona pandemic. That is a different issue which exists or not, how they have been dictated, how they are trying to impose their will, and their own media also, how they are trying to impose all these cultures, all these mandates. Why not these political parties, irrespective of their ideologies, as they have come together during this pandemic to create that panic or fear psychosis, to make people to submit to archaic epidemic act or disaster management act? Why not they come for the country's good together, all political parties and the media, so that once for all we get into this uniform civil code act, so that we can live life in a much better way, as he rightly stated in the preamble, whether it is equality or fraternity or liberty. I should state liberty, equality, or fraternity. All those intertwined, every citizen, irrespective of caste, creed, religion, or region, can really enjoy. Only then we feel this constitution, which has been submitted or which has been headed by B.R. Ambedkar and with so many intelligentsia lawmakers, will be fruitful, and it will definitely define our present while leading us to a wonderful future. So it is all in our hands. So let us understand that this inherited legacy of this great constitution once again will be reformed when it comes to the personal levels, so that every religion, the goodies in every religion are all put forward to rightful thinking, so that only one uniform civil code happens. I only wish that Supreme Court, as he rightly stated, whether it acts or not, but at least now the central government, all state governments and all the political parties. Mind you, in a people participatory constitutional democracy like India, we have political parties representing us. They are all representatives, whether assembly or parliament. And we have dedicated this constitution to ourselves. That means every individual is a constitutional authority by himself, whether it is from this religion or that religion. So I only hope political parties at least now understand the importance of this uniform civil code, and they will not stoop to playing electoral politics or divisive politics, so that this uniform civil code still remains a distant dream. So thank you, sir. If there is anything,
Thank
one
you.
liner you want to put it across to all the citizens of this great, wonderful country, one liner before I say bye
No,
on the eve of
I
this.
wish I wish all your subscribers and my fellow citizens a very happy Republic Day 2022. Thank you.
Thank you. This is for all from this day, and you will have a retelecast. We will try to again come out with a flyer and notify it. And definitely, we request Professor G.B. Reddy Garu to be regular on this channel as and when he gets time. Once again,
Thank you.
thank you, sir.
Thank
Take
you, sir.
care.
Thank you. Thank you. Thank you. Thank you.
For all the Indians, Sukha Nidra and Shubharatri for the world over. Good morning, good afternoon, and good evening. Bye, sir.
Thank you. Thank you.